He's known as a stalwart of the judiciary and a man of integrity. He's also someone who hasn't shied away from controversies or in criticizing anything that he sees as wrong. We're speaking to retired Supreme Court Justice Abhay S. Thank you so much, sir, for speaking to India Today. We're looking at a situation today, sir, and if I may start with the burning controversy today. We're looking at a situation where the collegium system, the appointment system, the shuffling of judges, everything seems to be coming together as a controversy with the judiciary and is seriously affecting the way the judiciary is perceived by the public. If I may take us through these questions first. At the moment, the biggest topic, Justice Nagaratna's dissent, the Collegium openly disagreeing on how appointments, who should be appointed, who should be recommended. How are you seeing these developments, sir?
Firstly, about the dissent, my experience about the Collegium is that it's not that decision is taken in one meeting. There are informal meetings when Chief Justice interacts with the Collegium judges, some names are discussed, and then on particular day a decision is taken. Now what remains to be seen is whether the issues which are raised by Justice Nagaratna, which were read in newspapers, whether those issues were discussed in depth in the Collegium. That's the most vital thing. Law permits decision to be taken by Collegium by majority. That's what the judgment of the larger bench says. But what is expected is that when one member of the Collegium expresses a view, that view should be considered by the other members, and then question of taking majority decision will arise.
But here, sir, we are seeing these questions of seniority of judges, how the High Court judges are being considered, what considerations are being put, what issues are being considered when the judges are being considered. So how are you seeing this debate? Because clearly the dissent and that has come out in public is about seniority, is about criteria that are being followed.
Over the years, you can find out, you can see from the Collegium resolutions that seniority is not the only criteria. But here, there is one issue which is raised by many and which needs to be dealt with. At one point of time, Supreme Court had 3 women judges, and now 2 of them have demitted office. So perhaps why at least 3 women judges who are senior to Justice Pancholi, why they were ignored? That's a question which will have to be debated upon. Seniority, to some extent, yes. But if you see the pattern, there is some kind of a state quota. You know, Bombay normally has 3 or 4, Delhi has 2 or 3. So when that is considered, all India seniority doesn't count at all. Because, for example, when I was appointed as a judge of the Supreme Court, in terms of all India seniority, at least 8 judges who were already there were junior to me, because they had come from different states. So that state quota was given representation. But surely, in this case, about 54 people who were senior to the candidate, they have been, I will not say overlooked, or they have been bypassed. But more worry is about why a woman judge was not taken.
So we're also seeing this entire question of shuffling of judges. In the last few weeks alone, there have been multiple instances where judges of high courts have been moved around. Some, in fact, if you see the latest Collegium resolution, some persons who were very recently moved from one high court to the other have now been moved. There are also questions being asked, if not openly, then at least in court corridors, about alleged misconduct by some high court judges. How are you seeing this, and what kind of impression is it sending out to the public?
So I think you are referring to the fact that from last week of May till today, about 35 or more transfers were proposed by the Supreme Court Collegium. I don't know how many have been cleared so far.
Some have.
Some have been cleared. And perhaps there is one judge of a high court who is again being sought to be transferred after a few weeks of his earlier transfer. Why this decision was taken by the Collegium, or these two decisions were taken by the Collegium, it remains to be seen, in the sense that I have no idea. But I think time has come now for the Supreme Court to take a call on the issue of transfers, maybe on the administrative side, maybe on the judicial side. Because you are right that within 3 months, if 35 judges of the High Court are transferred, now one of them is transferred within few weeks, perhaps reconsideration of the entire issue is necessary. And there may be different kinds of transfers. I mean, there are cases where some judges on their own have sought transfer, maybe because their close relative or family member was practicing, maybe for any other reason also. There were transfers effected in some high courts because there were not enough senior judges having experience, because you need experience to head division benches. So even for that reason, some time back, transfers were made, so that that particular high court gets senior judges. I'll give an example of Karnataka, for example. You know, for a period of 4 to 5 years, there were no appointments, and therefore you must have seen few senior judges going to Karnataka.
Transferred, yes.
So that is one reason. And the other reason which is perceived is that there are some allegations against the judges and therefore they are transferred. So I think time has come to reconsider the whole issue, because if so many judges are to be transferred, then I think on the judicial side or administrative side, this issue must be reconsidered.
See, if I may ask this, at one point there was a move to put in at least a couple of sentences or two in the Collegium resolutions that are published about the reason for either elevating somebody or for transferring somebody. It happened for a very short period of time, and then the decision was reversed. You were part of the Collegium when this decision was changed. Why not make the reason public if it is it's so innocuous enough reason, or why not make the reason public if the elevation is being done?
So let us take a different view about two different contingencies. One is elevation of lawyers as judges of the High Court. Today we have a scenario where many Chief Justices of the High Court find it difficult to persuade successful lawyers to accept judgeship. The main reason is uncertainty in the process and the delay which happens after Supreme Court clears the name. Now there will be deliberations in the Collegium. There are bar members, say either High Court or Supreme Court. High Court also has a Collegium. They consider cases as say 15 lawyers and ultimately agree for only 5. Now those lawyers will have to continue in practice. So if something is said in the Collegium resolution about their caliber, maybe their character, these people who are not approved, they have to go back and practice. So their privacy, their prospects in profession also have to be balanced. Privacy is there. For example, last year perhaps in some resolutions approving the recommendations for High Court, the Supreme Court resolution contained what was the income of the member of the bar. Now does it not offend privacy?
Okay.
So therefore, this privacy aspect needs to be considered. Now for example, transfers. Now something adverse is said about the judge in the resolution of transfer, it is made public. That judge has to go to some High Court and perform his duties. So this needs to be balanced. What I personally feel is only by publishing full resolution about transparency. The transparency has to be in the process.
So when we speak about transparency and we speak about what is happening in the court, and I'm moving on from the Collegium issue now to the recent controversies that have happened where a judgment is passed, then a larger bench has been constituted to maybe reverse it, maybe modify it. It has happened multiple times in the last 3 months alone, where if there is public outrage or there's political criticism, an issue is re-agitated before a larger bench. And we are also seeing this question of suo motu cognizance being taken of things which have caused public outrage, and then a different bench coming in to sort of settle the issue. And I'm not just talking about the most recent issue, I'm talking about, say, the Waqf matter, for example. We've seen this happen in the stray dogs case, we've seen this happen in several other judgments. One of your judgments, for example, is now before a larger bench. What kind of process goes behind it? And as a former judge of the court, as someone who's been in the system for such a long time, how do you see this? Because this does send a certain message to the public that if there is enough outrage or enough political criticism, then the courts are going back on what they are saying, or there is an incomprehensible or incorrect enough judgment coming out from certain benches. How are you seeing this?
Let us see the law as it stands. One scenario is there is interim order passed by a bench, which is not liked by many, which is criticized. I don't think because somebody has not liked the order, interim order, it can be transferred to other bench. Maybe if some party moves an application before the Chief Justice
but it is being done.
No, I'm just telling the legal position. If some party makes application for transfer, Chief Justice can transfer it, but he has to hear the parties. This is one scenario. Second scenario is where there is a final judgment. Now, if there is a final judgment, as review goes before the same bench, if one of the judges had demitted office, then it will go before a bench of which one judge is a party. And of course, if both the judges are demitted office, it can go to any bench.
So that is the law that you're talking about. What I'm asking is about what is actually happening.
Right. I'm coming to that. Now, you can't have modification because you can't go for review. That's the law laid down by the Supreme Court, that in the garb of modification application, you can't apply for review. So that law is settled. So therefore, it must go before same bench. Application for modification must go before same bench and same bench strength. So this is the law and it has to be followed. There is no dispute about it. Now these individual cases, we have to examine those cases, because one is, as you say, there is no reason for transfer, but case has been transferred, or a modification application goes before larger bench. That is one contingency. But when we examine these cases, we have to also examine sometimes there are connected matters which are pending before the stop.
Pause कर दीजिए.
Hello, कौन है?
Rolling? Sir, the thing is, I'm not asking about what the law is. You're talking about what the law is, what the procedure is. But we are seeing cases being transferred, the rosters being changed. How do you see this, and what kind of message is that sending to the people?
Actually, in such cases, there is no change of roster, change of quorum. If something is contrary to law, it should not happen, it should not be allowed to happen. But when we discuss such cases where one bench is seized of the matter, it either goes to other coordinate bench or it goes to the larger bench. We must find out why it has been done. Whether there was a transfer application before the Chief Justice and Chief Justice passed order after hearing the parties, or whether there was a connected case pending before the other bench, and then question of clubbing the cases arises. I'll give you an example. One judge is dealing with a two-judge bench is dealing with one issue, connected case with a larger bench. Then perhaps there is nothing wrong if the case pending before the bench of two goes to the larger bench. But if none of these grounds exist, legal grounds exist, then obviously such things are wrong. I don't think this should happen.
But it has happened, that is precise.
So therefore these cases will have to be examined. Why it has happened.
Okay. Now when we talk about why something is happening, if I may, there have been several instances in the last year or so where incomprehensible judgments by high courts have been flagged by the Supreme Court. Very, very recently, Justice Suryakant has made a comment in a public speech that the judgments given by performances by high court judges, some high court judges, are disappointing. You also very recently had said that judges should avoid preaching in their judgments because it sends a incorrect message. They should not do that. But it is happening, and we are seeing cases upon cases where certain moral discussions, moral debates, etc. are being made, or certain comments are being made by judges. How do you read this, and what is your message to those who are doing that?
See, two things will separate. One is what Justice Suryakant said about performance of some of the judges, and other is wrong judgments. Every judge must have delivered wrong judgments. I must have delivered wrong judgments. So we must minimize wrong judgments, and if wrong judgments are there, they can be corrected. If High Court gives wrong judgments, Supreme Court can correct it. If Supreme Court gives wrong judgments, we have seen cases where judgments were reviewed, and there are other proceedings also. About the first issue,
the incomprehensible judgments and questionable performance.
Incomprehensible judgments, of course, there cannot be incomprehensible judgment, and it has happened. Even Chief Justice of India said recently. So that should not happen. I mean, there is no question about it. About the performance, I respect the view expressed by Justice Suryakant. He has said it in a public speech. It was not on the judicial side. And it is welcome that if you are going to analyze the performance of Supreme Court judges and High Court judges, is welcome. But it is very comprehensive exercise. I will tell you, you can't go only by number of cases decided. Because I will give an example. Some judge, say in Bombay High Court, sitting on the original side taking up trials, he may not decide one case finally even in 2 months, because he will be conducting the trial, or the simultaneously trials will go on. Somebody is sitting for first appeal and second appeals, then there will be very few judgments. So number of judgments delivered by a judge can't be the sole criteria. That we must remember, because it depends on the roster which they are handling or cases which they are handling. Second test is, of course, of quality. Now that test has to be applied in the sense that all the judgments will have to be examined. And of course, we don't live in an ideal world. Most of the high courts, speaking for myself, Bombay High Court, year after year, day after day, the judges handle more than 100 cases per day. So there is bound to be some error committed. Judges are not expected to deal with so many matters. So quality, yes, certainly it can be assessed. Which judgments are contrary to the well-settled law, that can be easily assessed. Third aspect which is highlighted is delay in delivering judgments. Now there again, you have to find out how many judgments the judge has delivered during a particular year. If he has delivered large number of judgments, in that case, what is the percentage of judgments which were delayed? That also is a very relevant factor, because if judge is working hard, is delivering large number of judgments, maybe there may be delay of say few months in delivering the judgments. But that doesn't affect the quality or performance of the judge. So therefore, it's a combination of various factors. And when we say that some judge is incompetent, a very comprehensive study is required. All aspects are dealt with. We can't go by mere statistics. And I hope that Justice Suryakant, he is a senior judge, he is member of the Collegium, he may have seen that in practical terms. Therefore, he has said it. But it can't be a general statement, because you have to analyze performance of every judge.
Speaking of analysis of the performance of a judge, recently the Union Home Minister made a certain comment about a former judge of the Supreme Court who is now in the running for Vice President. You're one of the judges who spoke out against it. You're one of the judges who wrote a letter against it. How are you seeing this entire controversy? The Home Minister of a country making a comment that the court or the judgment is pro-Naxal.
It is as simple as this. Some of us read the judgment. We felt that the Honorable Home Minister had not put it correctly, because it all depends on the way you interpret the judgment, way you read the judgment. It's a judgment of the Supreme Court. So therefore, some of us felt that the interpretation put by the Honorable Leader was not correct. But some others may be also right, that their interpretation is different. So I think it's not a controversy as such. It's a debate. And debate and dissent has all the importance in democracy. So I may have said that this judgment should be read in a particular manner. Somebody else
There is
can
another
rightly say.
open letter now by another set of
Correct,
senior
correct.
judges.
So they may be also right. See, as judges, we can't maintain that we are always right.
Uh, the other big controversy of judiciary and executive right now is Justice Yashwant Verma's case. It is now before a committee under the Judges Inquiries Act. What is your take on this entire way the situation has gone, whether it comes to the in-house committee, whether it comes to the conduct of the inquiry and what is happening right now? Because you were on the bench when, I believe, when this entire situation
As far as Yashwant Verma
happened.
controversy is concerned, I am my own constraint because I was part of the Collegium which transferred Justice Yashwant Verma. So though I had limited office, it may not be appropriate for me to discuss issue of Justice Yashwant Verma. This is my consistent stand.
Okay.
About the action against the judges, of course, it calls for a debate. But when we have that debate, when we discuss Virasamy judgment, we say that without consent of the Chief Justice, FIR cannot be registered. I think we have to discuss so many aspects of it. Please remember kind of cases which we handle. And we live in adversarial system, so we can't decide in favor of both the parties. So one party is bound to be aggrieved. Now, if you are going to have a process which creates some kind of fear psychosis in the mind of judges, judges won't be able to decide without fear or favor. So balance has to be struck. And this in-house procedure, etc., is part of the judgment of the Supreme Court. So if somebody says that that is wrong, it will have to be reconsidered. Somebody will have to apply for reconsideration judgment of Justice KR, which is followed. And it's a very contentious issue because while somebody may with justification say that some and expeditious method must be available to deal with allegations of misconduct, but at the same time you must remember that it is very easy for parties to make allegations against the judges because we have an adversarial system of litigation, and if judges have to perform without fear and favor, they need some protection which is available today in terms of law.
So, in the book Incomplete Justice that is being launched soon, Justice Muralidhar, who is a former High Court judge, has commented on the reluctance shown by the Supreme Court in applying the general principle in decisions to the particular case where it matters the most. He's also talked about how sermons have been given on principles of justice, but when it comes to actually implementing, and I can cite an example for the matter, 5-judge bench judgments where the law is laid down, but ultimately the order is that, well, we cannot interfere, or well, we leave it to the executive to do something. How do you see this comment with regard to the reluctance of the Supreme Court to actually implement when it matters?
Yes, I read the entire book, Justice Muralidhar, and I'm going to say that same thing in the evening. If you read the last paragraph of his preface, he sets out object of writing the book. He says...
So I'm asking about your view on this comment.
I come to that. The object is that he wants to trigger dissent.
Dissent and debate.
Correct. Now, he has expressed this view. He may have expressed this view on the basis of certain decisions. And maybe I don't blame him when he makes this statement. But please read it correctly. It is not a general statement. In some cases, it could have happened, it must have happened. I can't deny that. But it's not a general statement. And why this statement is made by Justice Muralidhar is part of the judiciary. Because we also need course correction. Because if such criticism is there, when we sit as judges, we will remember that criticism and we will try to make course correction, and which normally every judge is expected to do. So therefore, I feel that there will be justification for Justice Muralidhar to make this criticism, but it's a constructive criticism.
Okay.
And it should be treated as constructive criticism.
What is your take on this, not just as a topic of debate, but where do you stand on this debate? That the law that is laid down is not always uniformly implemented by the court.
No, I also believe that some cases can be pointed out where the law is not uniformly applied. That can be pointed out. Nobody can dispute that. But merely because it has happened in few cases, it can't become a general rule. Generally, you can't criticize judiciary that is happening in every case. It must have happened and it has happened. I can't deny that.
Okay, sir. Thank you very much, Justice Oak, for giving us so much time. I wish we had a lot more time to discuss so many more matters, because judiciary and what the judiciary is doing, where and how it's affecting the political, social and legal debate in the country is something that always affects everyone in the country. And thank you, Justice Oak, for speaking to us so candidly. There are course corrections required in the judiciary, in the law, but where exactly is it going? That is something we have to see and we have to debate. In New Delhi, this is Anisha Mathur for India Today.